are some counties that are decreasing, but I don't know. I can't speak as to the whole Commonwealth.
The reason I asked the question, it occurs to me, and I would hope you educate me on it, that House Bill 44 in a deflationary time has a very, very different effect on citizens. If a person in tiny county owns a piece of property and that piece of property, the valuation of it goes down significantly, through House Bill 44 and the concept of the compensating rate, aren't we saying that that citizen is responsible, whatever the rate is, to bring in the same amount of revenue as last year?
Property tax is designed to never lose money from the previous year. It's always got a guarantee of at least the same amount of revenue. So
it seems to me that then, that being said, that in hard times when the price of someone's property is actually going down, we as a government are saying, well, it's your responsibility to make sure we have the same rate that we had last year, even though my property is worth a lot less to me. Would you agree with that assessment of it? Thank you.
Are there any other questions? Senator Reynolds?
Thank you, Mr. Chairman. Cindy, I appreciate your report. You're the only one of, I think, all of us that ever had to pass a test to get on the ballot to begin with, so thank you for that. But in all seriousness, at least where I come from in South Central Kentucky, when we get our tax bills every year, they're marked state, county, city, and school taxes along with any other taxing districts. And the biggest chunk or portion of the tax bill always goes to the schools. How are the schools related to House Bill 44? What is their mode of operation? I've never been on a school board, and I would like to know.
I can only speak as to what I know in Northern Kentucky. The schools do make up a significant portion of the bill, and Boone County schools make up half the bill. Walton Verona makes up 75% of the bill. Where I come from, the rates are the same. So those school boards are truly limited to 4%. They don't have the advantages, and I certainly use that term loosely, that maybe the library district has with the ability to take 11.5%, 12%. So the school districts that I have looked at are using the same rate for real and personal property, and therefore they are not manipulating the loophole to be able to take in more than their 4%.
So you don't think they can manipulate or find a loophole at all?
There are some, and I'm speaking as to something I know nothing about, but I know there's some kind of statute about 1990 and what the rates were in that time that guarantees them certain levels of revenue, but that gets into much more than I know anything about. So I can only tell you that as far as their real property tax rate is concerned, as long as the real property and the personal property rate are the same, which in most school districts I have looked at are the same. All the school districts I've looked at are the same. They are limited to 4%.
Thank you. Thank you, Mr. Chairman.
Are there any further questions? I'm going to try to finish this meeting by noon. We've got a few more things. We've opened up quite a line of discussion here, so I'm going to ask, is Dana Mayton still here from the Attorney General's office? Dana, Rick and Cindy, if you'd please stay there, and Dana, if you wouldn't mind, please come forward and introduce yourself for the record. I have a feeling, based on our conversation beforehand, you're limited in what you're able to say today, but we'd at least like to hear the limited part of what you're able to say.
Sure, Senator Thayer. I'm Dana Mayton. I'm the Deputy Attorney General. I'm also the former, actually the last Revenue Secretary when it was still a cabinet. So, I have some familiarity with this issue. The gentleman who actually drafted this opinion is actually out with a new baby, so he couldn't be here today. And I did mention to Senator Thayer ahead of time, usually when we issue an opinion, the opinion speaks for itself, and we don't try to, speculate about what it means, especially if there is an anticipation of litigation, which I think we're on record today that there is some anticipation of litigation on the matter. I think that as far as how we draft those opinions, we did seek the input from the various interested parties. Mr. Bergerman provided us with a very well-reasoned brief, if you will, on the matter, and then we sought input from other interested parties. And it was our determination that the Department of Local Government is calculating it according to the strict reading of the statute. Now, I think that you all are the ultimate policymakers, and we absolutely agree with that. And I think you're lucky that you have someone who not only brought you a problem, but said, here are 4 ways you can fix it. So, often you all get the problems and not the answers. So, in that respect, we would completely defer to the General Assembly about how you would want to proceed on that. And obviously, you all are going to take into consideration, just like we did, the opinions of all of your constituencies, including your county judges and your fiscal courts.
Thank you, Dana. Are there any questions? Not that she would be able to answer them, but Representative Lee?
I'd be glad to try.
Ms. Mayton, if a lawsuit were filed
Yes, sir.
and the constitutionality of House Bill 44 were challenged, would the Attorney General join in that litigation and oppose the plaintiffs in their attempt to have that statute declared unconstitutional?
It would be hard for me to answer that question definitively today, but as you know, Representative Lee, as a lawyer, when a constitutional challenge is filed, we are put on notice of that. We're not necessarily a party, but we have the option to intervene in that case and either defend the statute, or often we opt out because we get served with hundreds of lawsuits that do that. So it would really depend on our analysis of the allegations, and then a decision would be made whether or not to intervene.
If the question that was presented to the Attorney General's office by Ms. Rich, if there had been any question about the constitutionality, be the federal constitution or the state constitution, if there had been any question about the constitutionality of that statute, would your office had issued the opinion that it in fact did?
I guess the only real constitutional question we were presented was with regard to Section 59 and the classification sort of issue. And so to that point, we did address that in the opinion. I think it's in the last paragraph, and I know you've got a copy. So I guess it's hard for me to sit here and say, well, we would never issue an opinion if there was a question as to the constitutionality of something. I mean, we're going to evaluate it. Our lawyers are going to look at it and issue the opinion. That doesn't mean, and again, I wanted to remind you all, our opinions are advisory in nature, so that doesn't mean that a court or even a future AG might not overturn an opinion that we would issue.
One last question, Mr. Chairman.
Please
Under the
proceed.
current law, how much time does the Attorney General have to make a decision once they receive notice that a lawsuit's been filed challenging the constitutionality of a statute?
Oh, I would have to go back and check the rules. I would guess it's probably 20 or 30 days, but
Okay.
I can get back to you with that answer.
Thank you.
Senator Carroll, welcome back.
Thank you. I saw the congressman come around the corner just now, so I need to get on over there, but I did want to comment regarding the question. It does not have to be a plaintiff's actions, Representative Lee. It could be a declaratory judgment action,
Sure.
which is more appropriate. And in a declaratory judgment action, there is no plaintiff as such, merely asking the court to determine what the statute says, which is obviously the final word on the statute, and that's more than likely the kind of action that would be filed by counsel. I'm not trying to tell you what you should do, but that's probably what the court would interpret it as. I can't also overlook the opportunity to talk about farm property. One of the first questions I got hit with when I came to the General Assembly, by the way, in 1962 as a freshman legislator, was the valuation of farm property at its current market value. And I was quite astounded to find that with the growth of property, that farm property was becoming subdivision property, and that acreage was being determined to have the value of subdivision acreage valuation. So I introduced a legislation to propose a constitutional amendment to allow farm property to be assessed at farm values, which was passed and has been the law since that constitutional amendment was added to the statute, added to the Constitution. So we've protected our farm property, because all of our farm property is obviously assessed as PVA well knows at farm value. I additionally wanted to point out, as has just been stated by counsel from the Attorney General's office, that Attorney General's opinions are not written by the Attorney General. Attorney General's opinions are written by specific members of the Attorney General's office that are required to have knowledge in a particular field. And when an issue comes to the Attorney General's office, the particularly advisory opinion is always assigned to that individual who's as an expert presumably in a particular field. Obviously it becomes legally the opinion of the Attorney General, but we often call it General Conway or General Bashir's opinion, which is technically incorrect. It's the opinion of the particular lawyer, and it is an advisory opinion even at that. So I don't think it's quite fair to try to, for political purposes, to involve in a comment by any of us in a situation such as this, that we should infer that a particular sitting Attorney General is responsible for a particular opinion written by a member of his staff. And what we should be critical of is when he attempts to change it for political purposes. Thank you, Mr. Chairman.
Any further questions for Dana? Thank you, Dana. We appreciate you being here today. Mr. Hartley, I'd ask you to please come forward and introduce yourself for the record. Mr. Hartley is staff attorney for the Department of Local Government, which we've also referred to here today as GOLD, formerly known as the Governor's Office for Local Development, but I believe we passed Representative Riggs' bill that finally renamed it Department of Local Government.
Thank you all.
Please introduce yourself for the record.
Andrew Hartley. I'm again staff attorney with the Department for Local Government. We were indeed changed to Department for Local Government in the last session.
That was one of several House bills, by the way, that I'd like to point out that passed through the Senate State and Local Government Committee and went to the floor, became law.
I have with me Matt Froelich. He is a local government advisor with our department, and he is the person responsible for doing the tax rate calculations. He has a font of knowledge on the subject. The first thing I would like to do is to address Senator Carroll's question, and that question was whether we were correctly interpreting the intent of the statute. The compensating tax rate statute, which is KRS 132.010, it's actually a definition statute, and it's incredibly complicated, but it is no more and no less than a mathematical formula for calculating the compensating tax rate, which is the rate that will produce no more in revenue, and when applied to the current year's property, excluding, the previous year's property, excluding new and personal property, the same amount of revenue that was produced from the prior year. There is a long-standing legal principle that the intent of the legislature is to be ascertained from the text of a statute. And when the text of a statute is clear and unambiguous as to its intent, we are, as an agency, bound to the literal text of the law. And we believe, and the Attorney General's office as well, has confirmed that we are following a rigorous and literal wording of the statute when we calculate the compensating tax rate, which we do by law for all 120 counties. We calculate also the tax rates for certain taxing districts countywide, and we are also there to offer assistance to cities and special districts who would like assistance with calculating their own rates. Matt, did you want to?
Are there any questions? Senator Carroll.